The defendant approached him in an aggressive manner, stabbed him with a kitchen knife several times, then fled the scene. Carlina. That's you? Clause number 24 CR 1361 is called the State of Texas versus Carlina Solomon. Does the defendant waive a formal reading of the indictment and the arraignment? Mr. Turk, as your attorney, can we proceed in summary?
Yes, Judge.
In summary, this indictment alleges that on or about April 15th, 2024, in Jefferson County, Texas, you committed a second-degree felony of aggravated assault with a deadly weapon. Do you understand what you're charged with? And this deadly weapon was a knife.
Yes.
If convicted of a second-degree felony such as this, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Sure.
An agreement has been reached in your case where you would be pleading guilty and sentenced to 10 years in prison.
Yes.
Then that would be suspended. We would place you on regular probation for 10 years. You would be fined $1,500. There would be other terms and conditions of probation, which are normal and customary for this type of offense and also for the circumstances of this case. And this says, stay away
From Prince Hall Apartments, Judge.
from Prince. You will not be allowed to get near Prince Hall apartment. But you're here in MoMA. Is that your understanding of the agreement?
Yes, sir. And Your Honor, sorry to interrupt the court.
That's okay.
If I may, please, Your Honor, I'd at least want the court to know and the record to reflect that the state's offer, while this is a very serious offense, the allegations are very serious. The state's offer reflects the fact that she's 18, or at least 18 at the time, with no criminal history, and she has already served at least 63 days in jail, Your Honor.
All right. Is this your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this second-degree felony, aggravated assault with a deadly weapon? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty of this? I show you what's marked as State's Exhibit 1. Did you sign this?
Yes.
Understand? Discuss it with your attorney. Are the contents all true and correct? State's Exhibit 1 tendered into evidence.
Objection.
Without objection, it's admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with when the indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to an appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation by Mr. Turk for you. All of this is true at state, so help you God. State's Exhibit 1 is made a part of the record for all purposes. Pre-sentence report is waived.
Yes, Judge.
I am going to follow this agreement. I am going to find that you are mentally competent to enter your guilty plea. It is freely and voluntarily made. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this aggravated assault with a deadly weapon. I am going to follow this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of
Your Honor, sorry to interrupt the court again. Can we even do a straight probation on this? I know I made the offer, but now that I think about it.
I think you can do it in front of a jury, huh? Or stand by.
I'm thinking, I thought, okay. And so,
I don't think we can.
deadly weapon,
No. Does it have to be deferred?
there's the allegations are very serious, Judge, which is why I was kind of, my tendency was for a conviction.
I don't even think you can do a shot.
No, can't do a shot because
No.
That's what I'm
can't
saying.
give
I don't-
probation.
Yeah.
Fair probation.
It's kind of like-
Just for the court's information, the allegations are that there was a noise complaint at the Prince Hall Apartments. The resident came out and engaged this defendant. She stabbed that resident multiple times, Judge.
Well, it's a bit reductive, but that's a bit reductive.
It's a summary. It's my summary, at least.
All right. Unless I'm going to find something else. to dispose of it. What do you want to do right now?
And we have a moment to confer, please, Chair.
Go ahead.
Sure.
Sorry about that, Judge. I always forget about that court and the law.
We'll define it.
You
63 days.
You still got the face of my flesh, right?
I'm glad you caught it.
Yeah.
Um, look, I don't have a problem doing that. A positioning this to a deferred or unadjudicated probation. It's simple enough to do this. But the circumstances, let's say, the victim sustained stab wounds to his left shoulder, chest, and right leg, causing serious bodily injury. Several subjects were outside his apartment causing a disturbance. Well, he confronted them, of which he had every right to live peaceably, about the noise, and the defendant approached him in an aggressive manner, stabbed him with a kitchen knife several times, then fled the scene. All right. I don't have a problem placing him on deferred or unadjudicated, her on deferred or unadjudicated probation if that's what the state wants. But 63 days is
We
not.
would address that. We would
We've
address
agreed to
that.
180 days.
Okay.
That's what we're coming to tell you.
Because you don't stab.
No,
So they're trying to live peaceably, and they get the. If we're going to put you on deferred, you're going to also be subject to the most lengthy jail time as a condition of probation that we can assess for this, because this is preposterous. People shouldn't. They have a right to live peaceably, and by them complaining that their home was living in their home was disruptive because of what kind of shenanigans are going outside to be disruptive, then they shouldn't expect to be stabbed just because they had a rightful complaint, because he pays rent or lives out there or in some way, but he's paying.
Your Honor, if I may add, that the state has sent a letter to the victim of LeVar Menifee. It's what I refer to as my standard victim letter, asking him to contact our office and discuss the case. To date, that letter has not come back undelivered, and to date, we've not heard from Mr. Menifee. I just want to put that on the record.
Well, I'm going to ask the probation office to send something to the victim to find out, to get input from the victim on his damages, please. Care about the victims. Shouldn't have to be victimized. But when they are, there's a price that's paid. Okay, and 180 days, where were, let's see. You got your stay away from Prince Hall Apartments. We're going to also put 180 days county jail
Yes, sir.
Yes.
as a condition. Okay. And there's really no place to put this up, but I'm going to put it right after it's. All right. Is this your understanding of the plan then, that you would be fined, you would be placed on deferred or unadjudicated probation for up to 10 years in length? And you would be fined $1,500. There would be terms and conditions of probation, which are normal and customary for this type of offense. You will be required to stay off of Prince Hall Apartments property and serve 180 days in the county jail as a condition of probation.
Yes, sure.
And there are other terms and conditions of probation as well. If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty? I'll show you what's marked as State's Exhibit 1. Did you sign that? Understand it? Discuss it with your attorney? Are the contents all true and correct? State's Exhibit 1 tendered.
No objection.
Without objection admitted. It states that you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All true, so help you God. State's Exhibit 1, part of the record for all purposes. Pre-sentence report is waived.
Yes, Judge.
I will find you have pleaded guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. As you plead guilty to the second-degree felony of aggravated assault with a deadly weapon, there's sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt from State's Exhibit 1 admitted. But I am going to follow the recommendation and the agreement here by the parties. We will place you on deferred or unadjudicated probation for 10 years. There will be terms and conditions of probation, normal and customary for this. You must successfully complete an anger management program and pay all associated costs as part of your probation. You must stay off the Prince Hall Apartments location here. That's in Beaumont.
Put out there.
Okay, sorry. Prince Hall Apartments, Port Arthur, Texas. And there will be other terms and conditions of probation, which include you must serve 180 days in the county jail. Make sure you follow these requirements, ma'am. If you fail, your probation could be revoked. You could then be found guilty and sentenced to no less than 2 nor more than 20 years confinement. Knowing that, pay attention to following those requirements. All right.
Yes, sir.
Anything else?
No,
That is all.
Thank you.
We're assessing.